Now we are discussing an interesting question. If director holds only preference shares, is still restricted under section 185? Is a loan still restricted under section 185? Welcome back to our corporates. Today's question may sound technical but has deep compliance implications. If a director of the lending company holds only preference shares in the borrowing private company, can loan still be legally under section 185? So let's dive into what the law really says. Section 185 recap. Section 185 prohibits a company from giving a loan, guarantee, or security. Loan, guarantee, or security to a private company in which any director of the lending company is a director or member. Here the crux is member. The term is member. Who is member? Section 2 subsection 55 of Companies Act 2013. A person whose name is entered in the register of members is treated as a member. So this includes both equity and preference shareholders. So if a director holds preference shares, his name appears in the register of members, so he is legally a member. So the conclusion of view, therefore, yes, the restriction under section 185 will still apply even if the director holds only preference shares in the borrowing private company. So therefore, no exception or carve out under section 185 that excludes preference shareholders from the definition of members. So the implication of non-compliance, yes, penalties for violation, non-compliance with section 185 lead to company shall be punishable with fine, which shall not be less than 5 lakh, but which may extend to 25 lakh. And every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 6 months, or with the fine which shall not be less than 5 lakh rupees, but which may extend to 25 lakh rupees. The director or other person to whom any loan is advanced, or to whom any guarantee is given, or security is given, provided in connection with any loan taken by him or other person, shall be punishable with imprisonment which may extend to 6 months, or with fine, shall not be less than 5 lakh, but which may extend to 25 lakh rupees. This is what about the implications of non-compliance, penalties for violation of section 185. Hence, holding preference shares does not exempt the transaction under section 185 restrictions. Best practice, always check the type of nature of shareholding of directors before approving intercorporate loans. Don't assume preference shareholding is a harmless. It is legally qualifies as a membership. Take legal opinion, ambiguous cases to avoid penalties. So finally, even preference shareholders are members under the law. So if your director holds even one preference share in a borrowing private company, that loan is restricted unless it qualifies under permitted exceptions of 185 subsection 2. We have 2 channels. Please do subscribe and hit bell icon so that you will not miss any of the latest updates. We have RR Corporates and RR Legal Talks. Thank you.